Okay, so
All right,
sorry. It just
that's
does
fine.
that when I go in the waiting room. I don't know why.
Yeah, anyway, we're ready. So now this is case 2023-2017 DM, Chelsea Van Tattenhove versus Brian Van Tattenhove. It is Friday, January 19th, 2024 at 8:37 a.m.
Good morning to both of you. This is the time and place set for the trial in this matter, and I've been informed previously that all the child-related matters had been agreed upon. Is that correct, Ms. Van Tattenhove?
Yes,
And sir, is that correct?
Yes,
So the only issues we have is, again, issues of property and indebtedness. Correct?
yes.
yes.
Okay. Ma'am, because you are the plaintiff, then you would go first in this particular case. And what happens is what we're going to do is you have a right to make an opening statement if you wish to do so, or you can waive your opening statement and then just testify. That's up to you. What would you like to do, ma'am?
Yeah, I prepared a short statement if I could please
Okay,
read it.
go ahead.
A few paragraphs, so I'll get started. Your Honor, I asked Brian to supply the same report in Exhibit 3A from the binder that I provided for this trial. When I followed up with him directly, he refused to take the time to pull it, and out of respect and full transparency of our assets, I'd like to request him the time to pull that report because it takes 5 to 10 minutes. The report I provided clearly outlines 100% of my support as his wife and our children's mother for the duration of our marriage. Income volatility played a major role in family stress, and the report will help you, Your Honor, to compare apples to apples during this trial today. Why I ask is because finances are a main contributor of our differences, which broke down the relationship, as well as lifestyle choices that I became extremely uncomfortable with, nor were they conducive to family and marital growth. I was kept around to be the financial backer to the entire household, while he changed his business endeavors every 2 to 3 years and kept pressure upon me to explore a lifestyle I was uncomfortable with. The SSA report from the Social Security Administration shows a holistic snapshot to the cycles of pressure placed solely on one partner, while the defendant benefit from my 100% financial devotion to family stability until my health declined yet again in 2022. That decline was heavily weighted on lifestyle and financial stresses I simply couldn't endure any longer. It's unfortunate to be in this trial today and is not where I wanted to be at this point in my life. So out of respect for my children, their well-being, and my own, I just make this request again before you today, Your Honor, to allow a little bit of time here today for Brian to pull this report so you're able to see the whole picture and start with enough of the financial details to make a healthy and fair decisions to these assets in question today.
Okay.
Thank
Well,
you.
just to clarify, ma'am, just so you know, is obviously I can't directly look at anything that you provided. He doesn't have to.
Okay.
And secondly, it's your responsibility as a party to present your case, and that would be to present all testimony as it relates to the various assets. So if, for instance, as you're testifying, you testify and you miss an asset such that the court's not aware that that asset exists, the court's not going to address it, okay?
Okay.
So that's incumbent upon you. Mr. Van Tattenhove, you can do you have a opening statement to make? You can reserve your opening statement or you can waive your opening statement.
I'll make it really brief.
Okay, go
Throughout
ahead.
this whole process, I tried to convey the precedent and law in Michigan that all assets that are combined during a marriage, typically in the state of Michigan, are divided 50-50. On Chelsea's point about a certain exhibit that she presented in this stack of paperwork, there was years, around 5 years, that I spent working with her family to build a family farm where I invested time, material, and effort, and probably increased the property value of their farm by $100,000. That business dissolved and I got nothing out of it. So yeah, there's going to be, if we sit there and tit for tat on who made how much money a year, there's delinquency because I thought in good faith that I was building an asset that I would get down the line. So that's my response to her request.
Okay. Okay, thank you.
Yep.
Ma'am, at this point, you can present any witnesses that you would like or any testimony you would like yourself. Do you have any witnesses?
No.
Okay. And would you like to present testimony then, ma'am?
I guess as far as testimony, I'm just drained of this relationship. and
Well, let me
finances.
tell you, if, for instance, because this is the trial, if you present no testimony, there's nothing for the court to do then. I can't divide anything because I don't know that anything exists.
You need to present your paperwork.
Sir, you don't need to give her direction.
Okay.
Okay, that's what I'll do. So this would be the time to present any testimony about any assets that exist, any assets that you want to divide, any assets that you want to keep. So,
Okay,
that's up to you. And if,
Okay.
again, if they're not addressed, they won't be addressed by the court because I'll have no testimony and no evidence about those assets.
okay.
Okay?
So,
So why don't we do this, ma'am? We'll have you raise your right hand, be sworn in, and then you can proceed with testimony.
yes, sir.
All right, so raise your right hand, please. Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Go ahead, ma'am. What would you like to tell me about, again, about any of the assets or anything else in the case relevant to property division? I say that relevant because oftentimes people, when they testify, they think it's an open-ended opportunity to disparage or to vent or whatever else. And because the only issues you have are property, the only issue the courts are going to address is property issues, okay? So
Yes.
go ahead. What would you like to tell me, ma'am?
Well, I broke down in the binder that I provided, which hopefully you have access to right now.
Okay, let me tell you, you're gonna have to testify to this because this binder means nothing in the event that it's not introduced as exhibits. And as a result, you have to render testimony on all of those assets.
Okay.
Go ahead.
I would like to keep what is left of my 401k as emergency funds for me as I'm growing in my career. And I also would like to stay in the house and be able to sell it once the children have graduated school and are ready. I would like to not move them any more than they've already been moved over this past couple of years, 3 years. So that goes to Exhibit 1, 401k assets, and Exhibit 2, property, which I've outlined a lot of different options in there, or a couple of different options in Exhibit B.
Right
Which is-
now, ma'am, those are proposed exhibits. They've not been admitted, so
Okay,
you're gonna have to explain what they are when you say Exhibit 1. That tells me nothing, okay?
okay, yep. Exhibit 1 includes the 401k.
And where is it at? What's it with? How's it identified? What?
It is with Fidelity. And then there is another one with, I believe it's Matthews Incorporated. And those two assets are, let me just get are at about $5,000 for the Fidelity and about $11,000 for the Matthews. And then the property is the house I'm in right now, which is 153 Colonial Drive in Augusta, Michigan. And I would just like to assume and continue to keep making the mortgage payments each month. And at the time of sale, we'll be more than willing to give him half of the equity once that's a good time to do.
Okay.
Other assets, I really don't have a lot of other assets to bring to the table here that, would impact the children. So those are the two that I would like help with here.
Okay. Ma'am, on the real estate, do you know, have you had an appraisal done on the real estate or not?
Not quite yet. The defendant has been pushing me to sell the entire time. We've been having discussions about divorce, and I was adamant that it would be a further financial disruption and also debt on my part going forward, with increased interest rates, lack of being able to find a property in my price range in the school district, to help establish stability and keep stability for my work going forward.
And do you know how much the real estate, what the value is on the real estate?
Yes, I've worked with a realtor, and with their input, it's around $301,000. As is,
301?
yes, $301,000 for an estimated value right now.
And in this matter, do you know the amount of the mortgage or other liens against the property?
Yes, that is at $209,000 as far as the debt still owed on the mortgage.
Okay. So you have approximately a $92,000 equity.
Correct. And there are estimates in there that would require, a refinance in order to pay half the equity, which would put me in debt, in further debt.
Well, that's unfortunate, but I will tell you, oftentimes, as a result of divorce, people do end up going into debt, and that's unfortunate circumstance, but it does exist. Ma'am, is there any other assets that we need to address?
I did have our couches written in
Okay,
as
just
something.
personal. Do you have are there any vehicles that we have to address?
No, we've agreed to continue the way we are with our vehicles, separate.
Okay. Sir, I just ask you at this point if that's correct. You agreed that presumably what she's saying is that she keeps her vehicle, you keep your vehicle. Is that correct?
You're muted.
You have to unmute, sir. You're still muted. Hit the mic in the lower left-hand corner of your screen.
I was having the same issue.
Well, he wasn't earlier, so I don't know.
Hey, there we go. Sorry, my dog was barking earlier and I muted it. And
Okay.
yeah, I agree with the vehicle. I inherited mine. Hers is paid off. It is what it is.
Okay. Well, just for purposes of the court, so we know, ma'am, what vehicle do you have that you're going to keep?
An Audi A3,
And
2010.
what year?
2010.
And what vehicle is the defendant going to keep?
2012 Toyota 4Runner.
Okay. If you agree to that, that's fine. I'm just saying, ma'am, what you'll have to do is put those vehicles in the judgment, because you're gonna have to prepare a judgment in this matter. You're the plaintiff. So you'll have to identify those vehicles, and it would be best, I don't know if they're titled in each of your individual names. If they're not, you should have the vehicle and the VIN numbers put in the judgment, so that in the event, let's say, for instance, ma'am, you had a vehicle that was in your joint names and he won't sign off, there's no way for you to get that. But if you have the VIN number in the judgment, then that would in fact transfer the vehicle to you. So
Okay.
if the vehicles are each of your own names, that's not a problem, but just identify who gets what, just so that there's not an issue in the future. But again, if it's not, then you'll need the VIN number. Any other property, ma'am, that we have to address?
I had started in saying about the couches. Those were something I was hoping to keep through the process. And Brian and I talked about taking the amount of what those would be valued at off of, whatever amount it is that he would be awarded.
Okay. Are there any other that you're aware of, ma'am? Are there any bank accounts that the court needs to divide?
No, I do not want to divide any of his assets into mine, if that's, the basis of the question. I'm not asking for anything from him.
I ask that only because obviously you have a sizable equity in the home, and not that you would be taking anything from him, but the fact is you might want to offset. Let's say, for instance, he has an asset that's worth $40,000, and let's say you owe him on the property. Let's say you owe, looking at the price now, would be $46,000. If he has something worth 40, you can offset that against that asset, so you wouldn't owe him as much.
I would like to offset the dirt bikes and all of the assets used for extracurricular activities in that way. That's something.
Okay. If that's the case, that's fine, but you've got to render testimony, because until you brought dirt bikes, I have no idea that there's dirt bikes. I don't know what they are. I don't know how much they're worth. I don't know any of that.
Sure. Yeah. There are a number of dirt bikes that are still.
Okay, that, again, a number doesn't tell me. I need to know which ones they are, what they're worth.
I don't have all of that information today. I would need
Well,
his
today's
help.
a trial, and this is where you have to have that information available.
Well, then it needs to not go into it then.
Okay.
It's information I'm not privy to, but was family money spent for.
Anything else, ma'am, that you would like to tell me?
Other than what I already came up with in the very beginning with that short statement I made. I'm just looking out for the well-being of my children and to not incur any additional emotional stress on them from our separation and divorce. So I'm asking and coming to the court, for a fair split.
Okay, thank you. What we'll do is probably take some testimony from the defendant, and then maybe at that point that'll assist us as well. Mr. Van Tattenhove, if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Sir, well, you've heard the testimony of your wife. Anything that you would like to say as it relates to her testimony?
Yes, I would like to call Exhibit 1A that she submitted. On the first page.
Okay, let me get to 1A first.
Yep.
Okay, I've got that.
Going through from top to bottom, this is an exhibit that shows money that was removed from a 401k over the course of the past 15 months or so. From what I gathered out of this paperwork is that at one time there was nearly I think $74,000 in one account, and to what I can pull out of this, because I haven't been privy to any of this information, was somewhere in the neighborhood of $100,000 total in 401k. And over the course of the past year and a half, Chelsea has been taking money out of that 401k to live off of instead of working full time. And in this, it outlines what she spent that money on. I do not agree that she spent $11,000 in counseling in 1 month. The mortgage that she outlines that she paid from 9/1 to 2/17 of $33,454.96. At that time, I was paying half of the mortgage. The same thing with 1/18 to 4/17. She outlines that she spent $5,800. I paid $3,440 of that. And again, 12/5/23 to 12/23, she lists $1,600. I paid $800 of that. So what she's trying to show in this exhibit is that over the past year and a half, she has liquidated around $70,000 of our family assets to pay for debts that a typical adult would pay for out of their income. That leads me to Exhibit 3A that she supplied and asked for me to supply. On the back side of that, what you will notice is that, as is common with an adult that graduates college around 2006, she started out making $32,000 a year. Over the course of the next, 15, 16 years, she was up to the $69,000, $66,000 to $70,000 range. And then in 2012, 6 months before the first withdrawal from her 401k statement in September, she quit her job.
I did not quit.
Okay, ma'am, it's not your time to talk. You can have another time in a little bit.
she will say she didn't quit, but she resigned from the position or restructured her from a salaried position to a contract position, and then the company never contracted her. It was after that, and in her binder of exhibits here, there's, let's see. Let's see, exhibit 3. Let's see, I'm not finding an A. Oh, that, yeah, 3A is the income statement. 3B and 3C. She is showing letters of intent of employment for a part-time job working as a waitress and a bartender. What I don't see in here is a copy of a letter of intent from Angel's Gentleman Club, where she bartends on the weekends at a strip club. So my case, or my point in illustrating those documents, is that the income that our family was accustomed to was purposely removed. And over the course of the past year and a half, $70,000, because she shows in 1A what she spent the money on, but that's for the money that she received. That's not for the totality of the amount taken out of the 401k, because they nicked her in taxes. So from what I can tell, there's $70,000 that were vacated out of the 401k to pay for common expenses that an adult would pay for, which are no longer assets that could be divided now in divorce.
Okay.
I will go to the documents that I supplied to the court. I will start with defendant document A. This outlines my debts as they sit today, which is somewhere, let's see, 28, 38, 45,000. I mean, I commonly use my phone as a calculator, but I'm on a Zoom call. So I'm just going to say that's around 45,000 that I still hold in debt. I don't believe Chelsea has any more personal debt because, to my knowledge, she used the 401k to wipe out her credit cards and personal loans. Then I will go to, in good faith, I will go to document D, the last one, because that's the only one that really matters. And this outlines the large value or larger value assets that I hold. One is that 4Runner, but as we said, that's off the table. I actually inherited that vehicle when my father passed, so it doesn't count in divorce either way. But that does outline the 66 Mustang that I owe and the KTM dirt bike that I own. The other dirt bikes that are in the family possession are those of my children. And they will maintain those and keep those dirt bikes. So I guess in summation, Chelsea herself submitted documents that showed at one time, not that long ago, that she was making around $70,000 a year and that she liquidated our family assets to live off of for the past year and a half because the assets that she liquidated are really close to the amount of money that she made. And now they're not left to divide up.
Okay, sir, just to follow up, if you could, you said that the forerunner was inherited. Explain that to me. When was it inherited? How was it inherited?
It was inherited. My father passed away, what, 3 or 4 years ago. It was part of his estate. I took his dog also when he passed. And at the time I had a truck that I couldn't put my family and 2 dogs in. So as part of the estate, I was awarded the forerunner so that my kids, wife at the time, and 2 dogs could fit in it versus my pickup truck.
Okay, was that vehicle put in your sole name?
Yes.
Okay. And the other vehicles that you've identified, the 66 Ford Mustang, you have a value of $8,000. Is that correct?
Yes.
And then the dirt bike is 4,500.
Yeah, that's what I paid for it. It's not even worth that now, but sure.
Well, you identified it. I'm not.
Yep.
Those numbers
I'm
are.
fine with it.
You also identified on this document under B, you stated that effectively you had about $5,000 in a checking account, as you said, a business checking account and then a personal account. They total
Yes.
about $5,000.
Yes, sir.
Okay. Is that accurate?
Yes.
And presumably you wish to keep those accounts.
Yes, sir.
Is there any other property that the court needs to address?
Not that I know of. Everything else, to my knowledge, like even those couches, I think Chelsea said that at one time they were worth 10 grand, but that was a dozen years ago and we bought them. I mean, street value today, if I had to sell them on Facebook Marketplace, I might get 2 grand for them. You know, we're not dividing up what an asset was when it was new. We're dividing up what it's worth today. Other than that, I think everything else is maybe per incident less than $1,500, and there isn't that much of them. So we can figure that out as we move.
Okay. You had identified some debts, but I don't see any verification or anything of that nature. Do you have any thing to verify and confirm the debts, or is that just your assertion?
I could supply.
Don't say you could. Today was the
Yeah.
trial date. You had to have supplied that prior to today's date.
I just filled out the paperwork that this court supplied. It didn't ask for receipts, but I gave it in good faith that that's what I have.
Okay. Anything else, sir, that you would like me to be aware of?
No, not as far as assets go.
Ma'am, I'm gonna go back to you. You have a chance to rebut or, I guess, clarify or confirm anything that the defendant has stated.
Yeah, I would like to clarify about quitting my job.
Okay, go ahead.
I did not quit my job. I went on medical leave in 2022 due to stress and it impacting my health. Increase in migraine and also just emotional anxiety and stress, causing me a lot of mind fog and trouble in performing my work. So with the grace of my work, my prior work that had funded our family, for that lifetime that I can show, I worked with doctors and my counselor to perform a plan to go down to part-time work to spend more time on the family and in a sense, work with Brian on our marriage or divorce, because it came down to that, and it's come down to that a couple of times throughout the last, I would say, 8 years. So a good back half of our marriage was very rocky, very stressful on me. And it came to a head in 2022 where I needed reprieve from that. And over that time, I had asked for that help. He was climbing financially, which is why I asked for that in good faith, getting that lifetime income report that only takes a short minute to get. And that stress solely placed on me over this time took its toll. And I did what I could to get the hours I could from my work. They could only promise that I was a flex contract worker. And I was hoping out of that, in agreement with my manager at the time, that I should, get around 20 to 30 hours a week, possibly, working on projects and supporting my team. That business changed. Over the course of 2022, I was given some hours, and then it slowly fizzled into nothing. So I am still able to be a flex worker, and I am on that roster for being a flex worker in my graphics position. There just isn't any work, and it's, they have to pay me to clock in. If they don't have the work, they cannot pay me, obviously. So I went out, I found additional work to start supplementing and getting back to work, because with my plan from my counselors and my doctor, there was a go back to work plan. And I did go back to work, and I have been working. He says part-time, although I fill in contract hours at Angels Gentlemen's Club for office hours, as well as pick up bartending shifts as needed, as I'm a backup to that. And from there, that income wasn't great. So I added Ned's, which is another letter of intent in the exhibits Brian brought out under income. Exhibit B.
Kind of give me an idea, ma'am, in a given month, how much, or you can do it by week, whatever it works out, on an average, what is your average income?
Right now, we've estimated that, because it does flex with tips, to be around $2,800
A
a
month?
month. Yes, a month.
Well, obviously, there's a lot of jobs available because of the job market that you could, and most of those jobs would pay, $15 an hour just to start. which would give you at least comparable to what you would make. Have you looked at any other full-time employment?
I've started to, it's a challenge, because I'm investing myself into Ned's right now, most of my time, to open another branch of their business, actually two more branches of business, because there's significant growth where I would become a manager. And that has been the path I've been taking to become a manager and make more than $15 an hour, as I'm building and getting my tenure there. And that business, one of which has a letter of intent in there to be mine. And that would be under Exhibit B. There are two letters from Ned's. One is about my current work, and the next is about the intent to open the business.
Well, I would tell you, did note in skimming through that the letters were there, but that is obviously hearsay, as the person is not here in court to testify, so the court will not consider any hearsay exhibits.
Well, that is my goal and intent in process right now.
Your husband had stated that you had liquidated some of your 401k. Is that accurate?
It is. I did that in emergency mode. We were not getting along. I was not supported through my medical leave, as well as met with a lot of resistance to take on certain bills. And during that time, I felt it was emergent to make sure to maintain the household for the kids, as well as continue to grow out of my medical leave and into a new career that would end up supporting all of us again, was the intent.
Why couldn't you have just continued the employment that you were on that gave you a healthy income?
My mental state, given our emotional and very toxic past, like I said, there was a lifestyle I was not comfortable with anymore and met with a lot of resistance to change that. And at the end of the day, this is what I needed in order to heal. And I'd also like to say, over the lifetime of income, there's never been a life savings of any kind on his part. I know he's showing savings now, but the income volatility due to, his projects, which the farm was one of many that he tried and most failed up until this point. So his income contributions to the family had never supported us in the way mine has. And at the time when his started to climb and to become more stable, I was asking for help. I was asking him to please help me manage the family and to please take on, some of these family bills, including, electric and consumers bills, that kind of thing. Just mean, like he was saying, the things that all adults would need to pay, as I had been most of our relationship. So if I can revert to exhibit, give me 1 second here, please. Just want to find the right one to point to.
Well, none of the proposed exhibits have been admitted and they've not been asked to be admitted, so court simply will not reference those until they are admitted.
How do we get those admitted?
Well, what you do is you have to lay a foundation to admit it. And some, obviously, I don't know if defendant's gonna object. He may object to an exhibit, so you have to address and lay a proper foundation. The foundation would be that whatever the exhibit is, that it's an accurate representation, that it's not been altered in any way. And again, I can't speak to it because each of these proposed exhibits are different. So there's a lot of different foundational requirements that have to be established to get those in. Again, and it's subject to any objection that the defendant may make, or vice versa. The same thing as he has an exhibit, you have a right to object to that as well.
Okay.
And so if you can lay a foundation and there's no objection, then the court will admit it. Otherwise, the court won't, and then will not consider it.
Okay.
Anything else, ma'am, that you would like me to be aware of?
Just the emotional side. There's a lot that went into us coming to this point. I didn't want to be at this point. I wanted growth over our relationship. And over the course of our counseling, mine individually and his, his sparse participation, especially as of more recent years, led to this. And to me, I made the decision to file because of unhealthy circumstances. And I'm looking for healthy for my children and for myself and for Brian. The only other thing that I can think of that we have not discussed today was his recent incarceration.
Okay, unless that pertains to property, the court's not interested in that.
Okay. So in terms of property, no, there's nothing else. It's just that fallout.
Do you acknowledge, as the defendant stated, that over the last year and a half or so that you depleted approximately 70,000 from your 401ks?
Yes, I was met with resistance to help pay bills, which are in exhibits in this, if I can call those forth.
Okay. Anything else that you'd like me to be aware of?
Not at this time.
Sir, is there anything else that you would like court to consider?
Well, I guess I would have to do, how did you say to submit evidence?
Okay, what you have to do is you have to identify whatever the exhibits are. You have to identify the reliability of the exhibits, obviously that they're relevant, and then you would have to move to admit those particular exhibits. And that'd be subject to any objection that might be made by the other side.
All right, so I will start with 1A that Chelsea submitted. I believe this illustrates the topic of her liquidating our family assets over the past year and a half.
Well, sir, she's testified. Let me say she's testified and acknowledged approximately 70,000 as you testified to. So again, the exhibit would simply be duplicative of that, of her testimony.
Okay, so that would cover exhibits 1A and 1B, correct? Okay, I believe so.
You're offering, sir,
we're amateurs here. We've never been through this. I
I
apologize.
understand that, but as a result, when you do represent yourself, you're held to the same standard as attorneys are, because the court simply can't have rules that pertains to attorneys and rules that pertain to persons appearing in pro per. The same rules apply.
Okay, so I guess my understanding is that 1A is covered in both of our testimony. So would I have to submit that, or is that accepted for review?
It's up to you, sir. You can.
I would like to submit it.
You would like to offer it as an exhibit.
Yes, sir.
Miss Van Tattenhove, what is your response to him offering plaintiff's exhibit 1A?
I'm sorry, did you say Ms.?
Yes, yes. He's offered that as a proposed exhibit, which you submitted. What is your response to his offer of that?
What, I don't understand what the offer is. I mean, that's the.
You have an exhibit, the exhibit's identified, you offer it into the court as an exhibit. You have a right to object to the offer for whatever reason that you might have to object to that exhibit. I'm just asking you if you have an objection to his offer of the exhibit.
No, it is the truth. It
Okay.
is an exhibit. I
Okay.
provided it myself, so.
The court will admit plaintiff's exhibit 1A, there being no objection.
Okay, I would like to identify exhibit 1B. That is also part of the 401k.
Okay. That's the, it says Eaton Savings Plan. Is that correct?
The 1A is the Eaton Savings Plan, I believe. Is part of it. And then 1B is the Matthews. There's two different 401k accounts.
Well, the way they're identified by the 1C is the Matthews, 1B is the Eaton's plan.
Ah, gotcha. Sorry, my sticky note may have moved on me. So A, B, and C are all the ones that pertain to the 401k.
And you move to admit plaintiff's proposed exhibit 1B and 1C.
Yes, sir.
Pam, do you have any objection?
I just need a moment to think, please. No, I don't object. I gave them to you. I gave them to the court and I gave them to him, so.
Okay.
Well, can I ask a question, please?
Let me address this, or do you have an objection at this point?
No.
Okay. Court will admit plaintiff's exhibit 1B and 1C, there being no objection. Sir, just to clarify, the Eaton Savings Plan showed sometime prior to the filing, the date of filing was 7/31/2023, showed a balance in the Eaton Savings Plan. Well, it'd probably be somewhere. As of 1/13/23, it was just over $16,000. Is that? Well, it's in the exactament. Is that accurate as best you understand as of that date?
Yes, I believe that it was around 22,000 at date of filing, but in the document A, it shows that she took another $18,000 out even after she submitted the $22,000 in the court documents, and now it's down to $4,498. So even after it was submitted as an asset to the court, it was further liquidated. I believe it went from $74,220 down to $4,498,000 over the past year and a
What
half.
I'm doing is I'm looking for, do you have any documents or other evidence to establish what it went from to what it is?
In that paperwork, it says the $73,699
Where does it say that, sir?
under Eaton statement details. At the top of the page, it says 1/11/24 at 3:16 p.m. At the top right of the paperwork. For me, it's the second to last page back.
Okay, you're gonna have to identify it better than that to say it's in the top left corner. I've got a binder full of documents that are, obviously, I've only got a few that are exhibits, so I don't know what you're referring to.
Okay, so in 1B,
Okay. What page?
oh, there it is at the bottom. Let's see. So 1B is the Eaton. That is page 1 of 3. Near 3/4 of the way down, it's saying what the market value was of that 401k.
But that was back in 2022.
Yes, because that's when Chelsea deemed us separated.
Okay, well, I'm looking at the date of filing.
Okay, so the date of filing was, $25,576.
25,000.
That's on page 1 of 1. It says 8/18. Well, that says 8/18/22.
I'm looking for the date of filing being July of 2023. Do we have anything close to that?
I've got 11/28/23. That's on page 1, $22,852.
What would, give that to me again? What
On
date?
page 1 of 1,
Okay,
11/28/23. That date, that's the closest date I can get to you.
okay,
It's
22,000.
Yep, $22,852.
Okay. So we've got that date as closest to the date of filing that we have.
Yeah, I guess what I was trying to illustrate before is that it was from the time, go ahead.
That's fine. What do you have as it relates to the Matthews as of the date of filing? As close as you can. The court has admitted 1C, and if you can correct me, it looks at the it says vested balance as of March 31, 2022, $9,406.35.
Yeah, hold on, I'm rifling through it. I've got a couple pages back, couple more pages, 4 pages back in that stack. I've got a 12/31/23 that says $12,800. What is my account balance?
That's December 2023.
Yes.
Okay, I said I wanted to look at something close to the date of filing. And the best I have is the March 31, 22. Unless you have something else better.
Well, I mean, isn't the day after that? I mean, 12/31/23 is closer than March 31st, 22, right?
From the date of filing, I don't think so, sir. Maybe your math's different, but
Oh, it's fine. I'm not gonna nickel and dime over $1,300.
okay. Okay. Anything else, sir?
The only other thing I have, yes, is that exhibit 3A with the lifetime savings or lifetime earnings that shows Chelsea's significant fall off in income in 22, which would directly correlate to those 401k statements. I will go on the record to say that I paid bills towards our house. I paid almost 50% of our total bills. So when Mrs. Van Tatenhove makes statements as if she paid for everything, that was not the case. She did not pay for everything. The car she drives, I paid for the whole thing. I contributed to utilities for the past year and a half. I've paid half the mortgage and all the utilities, all the cell phones, and all the internets for our house. She did contribute a payment here and there on specific bills, but it was nothing frequent or you know.
Okay. Sir, I didn't get through any testimony as to your current income.
I take home around $74,000 a year. It varies.
Well, what is your gross? I don't care what you take home. I want your
That
gross.
is my gross.
Okay.
I have a business, but there's obviously business expenses, taxes and insurance. I have
That's
to
fine.
carry
That's fine. I
liability.
just needed a gross amount so we can calculate child support.
Yep. I did have a question with child support. From my understanding during mediation, the factors that are taken into account are overnights and insurance. Is that
Yes,
correct?
if there's someone is paying the insurance, that would be a deduction from their income.
Okay, I do wonder if lifestyle costs are
No.
factored into that at all?
No, they're not.
Okay.
Okay, anything else, sir?
I will submit my exhibit A that shows my current debts. I will submit B, which has my bank account statements on it.
Okay, we'd already got testimony about that, so.
Yep, and D. I just want to make it known that I submitted it.
Okay. Okay. Anything else?
Not to my knowledge, no.
Okay, ma'am, any additional testimony or witnesses or exhibits at this point?
Yes, I would like to call forth exhibits, please. To his statement on paying everything or paying half of anything, I would like to call exhibit 3E. There's showing delinquencies where he was saying he was paying, and had agreed to pay for all of these bills up through divorce, basically, that were delinquent, which I caught up and paid. So that would be 3E. under the income tab.
Okay.
There's an
That's-
account history there, and then there are some exhibits of bills that were going unpaid that I made current. I would also like to call Exhibit 5. There's A, B, and C. I would like to come into as evidence.
Well, I look at those, they don't pertain to, again, the property issues, so the court wouldn't consider those in any event.
Okay,
With that, it looks like in this particular case that we have concluded the testimony and offer of any evidence. So, Ms. Van Tatenhove, you have an opportunity to make a closing statement if you wish to do so.
in my closing statement, I would like to say that my kids, our kids, are of my most important, thought in this whole matter, and their stability. And moving them would be detrimental at this point. They've already moved out with their dad. He has now made his own living quarters and has had them a week on, week off for the past, I think we're at 3 or almost 4 weeks now. So operating as divorced, it was a bit of surprise. I had been met with a lot of resistance of him moving out, as that was my request much earlier on in our disagreements. And that was a surprise right after Christmas that he was ready and did. So knowing he's able to, provide and have his own domain for them, I would like to have the opportunity to maintain and grow in the same domain as I am in now.
Okay.
For my children.
Okay. Anything else in your closing argument?
No, sir, just looking for fair.
Okay, I do have something to ask, only that, again, because we didn't address it on your testimony in this matter. You filed the complaint in this matter back on or about July 31, 2023. At the time that you filed that complaint, had you resided in the county of Calhoun and the state of Michigan for more than 180 days immediately preceding the filing?
Yes,
And in this matter, you state that there had been a breakdown of the marital relationship to the extent the objects of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. Is that a correct statement?
yes, sir.
Any chance that you can reconcile, live together as husband and wife?
No,
Are you currently pregnant, ma'am?
no, sir.
Okay, thank you. Sir, any closing argument you'd like to make?
Just that I hope the court takes into consideration the liquidation of assets over the past year, and the evidence presented that financial, I'm trying to think of how my mom put it, a financial abandonment of the family took place over the past year and a half. And that, notwithstanding, I don't understand how assets could be divided without the sale of the house. I did move out a couple weeks ago because I noticed, we're at the end of this divorce here and people need to move on with their life. I do have a house that's less than a mile from the school, and I have no issues if Mrs. Van Tatenhove cannot find adequate housing in the school district, being a full-time parent.
Okay. Thank you. What that concludes the proofs in this matter. What the court is going to do is I'm gonna put you in the waiting room and then, Court, I have a bunch of things I have to check as far as the numbers that you've given me, and then we'll bring you back in. It'll probably be about 20 minutes or so, and then we'll give you a ruling at that time. Okay, so we'll just put you in the waiting room and please be patient. The only issues before the court were, again, the division of the assets in this matter. I'll tell you in this case that first, the court will find that their testimony has shown that there has been a breakdown of the marital relationship. In this matter, the court will preserve the proofs pending receipt of the proposed judgment. Ma'am, you're going to have to prepare a judgment of divorce, a uniform child support order, and a judgment information form in this matter, as you are the plaintiff. Court will note that pursuant to the applicable statute in this matter, which is MCL 552.17, court is required to make an equitable division of property, but the division need not always be mathematically equal. Division is one that is roughly congruent pursuant to Jensen v. Jensen 205, Mishap 169, a 1994 case. There is no exhaustive list of factors the court must consider to determine what is equitable, but the court will use and must use its discretion considering all the circumstances of the case. The case of Sparks v. Sparks at 440 Mish 141, 1992 case, the Supreme Court did provide a non-exhaustive list of what the court should consider well, the citation to Sparks is inaccurate. It was just in my notes. Court will note in this case that in the case of Booth v. Booth, that the court has directed that a pension is divisible as a property settlement. When they say pension, that's retirement, 401k, etc. Court has to consider what are marital assets, and that's any increase in net worth that may have accrued between the beginning and the end of the marriage. And that's citing the Bone v. Bone case at 148 Mishap 834, a 1986 case. In this matter, the court, in looking at all of this, the court does note that, and looking over the exhibits that were admitted in this case, the plaintiff's exhibit 1B and 1A, 1B, and 1C in this case, that it does show that at or about the time of filing, the Eatons retirement did have approximately at $22,852. The Matthews had about $9,406.31, totaling $32,260. The current amounts that are left in that account, as testified by the plaintiff in the Eaton, is about $5,000, and the amount in the Matthews is $11,000. So those total $16,000. In this particular matter, half of the amount as of the date of filing would have been approximately $16,000. And again, the balance is approximately $16,000. So the court is going to award to the defendant the balance in the Eatons and the Matthews retirement accounts as of the current date, which is approximately $16,000. So the court would award that amount to him as of today's date. Sir, in this matter, I'm going to direct to you because I'm awarding you those pensions. The plaintiff is going to have to include that in the judgment, but for you to get those, you're going to have to prepare what's called a qualified domestic relations order, a QDRO. And that would, in fact, award to you the balance in those accounts as of today's date. So again, if she acquires other or accrues others in that after today's date, she's entitled to that. You will get in what's in there in today's date, which is the approximate $16,000. The court will award to the plaintiff for 2010 Audi automobile and to the defendant the 2012 Toyota 4Runner, which he inherited, which the parties had already agreed and stipulated to. The court would award to the defendant the 1966 Ford Mustang, his KIM 150 dirt bike, and the various bank accounts that were identified in his exhibit in this case. All three of those assets equate to $17,500. The court will, in this matter, the other asset that the court has to address is the real property at 153 Colonial Drive, Augusta, Michigan. The plaintiff had testified it had a value of approximately $301,000, a mortgage of $209,000, and that leaves an equity of $92,000. One half of that equity is $46,000. The court is awarding to the defendant an equity in that house of $46,000, less the $17,500 in the three assets that the court had identified having a value of $17,500. That means that out of the home, he has left what would be owed to him the sum of $28,500, which the court will award to him in this particular matter. What the court is going to do, the court does note that the plaintiff is not employed as she had previously been employed. She said that the explanation, she said that she did not quit. She went to part-time because of medical reasons occurring in 2022, and migraines, stress, mind fog, and she went down in the work to a point where she was making, in this matter, she was making approximately $2,800 per month, with obviously has an opportunity to increase that as she progresses, if she does, as she has stated. Court is going to consider that as her income for purposes of child support of $2,800 per month. That would in fact exceed a minimum income based on the current employment climate and the need of work, which is usually around $15 an hour. That would be more than that. So the court is taking that as her income at the current time. The court would in fact recognize that the defendant has income of, as he stated, his gross income of $74,000. That'll be utilized for calculation of child support. As it relates to the house, as I stated, the defendant has an equity which needs to be paid to him of $28,500. In view of the circumstances of the parties and the need, if you would, for the plaintiff to, again, get on her feet, get established, et cetera, it's going to take some time. The court is going to order that she would pay that sum of $28,500 within 1 year of today's date. Failing to pay that amount, then at that point, if she can't refinance or pay him out, failing to do so, that at that time, the house would be listed for sale and sold. And then he would receive that amount of money at that time. The balance would be payable to the plaintiff. Court notes the court is doing this and taking into consideration all of the testimony that was given in this matter. I will say that unfortunately the parties were unrepresented, and that did again impact the case because again they were unable to develop much of the testimony. They did not give much testimony that would be appropriate in these types of cases as it relates to assets, debts, etc. The court is going to order in this matter that each party would pay the respective debts in their name or encumbering any assets they are to receive in this matter. The court does note that I should mention that with regard to the liquidation on the 401k. There was testimony, obviously, as to her liquidation, which was for over a period of a year and a half. I would note that, again, a year of that was prior to the filing in this particular matter. The court does note that she had submitted various bills that she was paying at that time. The court is also considering the fact that the defendant testified that at that time, he likewise was contributing to the household mortgage, apparently based upon his testimony. But notwithstanding that, it did appear that much of that liquidation, other than the amounts the court had stated as of the date of filing, that liquidation was utilized to support the household at a time when the defendant was residing in the household. And he stated he only recently had vacated the home as the parties were obviously going to be divorced in this particular matter. So the court will not attribute those amounts that were liquidated to the plaintiff as they were utilized to pay joint bills and joint obligations in this matter. With that, the court, that concludes and addresses all the issues of property as well as debt in this matter. I'll ask Ms. Van Tattenhove, is there anything else that you believe the court has failed to address or has not addressed prior to concluding this matter?
You had already dismissed the exhibit I was hoping could come into play here, but I don't want to upset the case in any way. So beyond that, no, I don't believe so.
Okay. Mr. Van Tattenhove, is there anything else you believe the court has failed to address or needs to address before we conclude?
The only thing that I can think of is I would ask the court to require Chelsea to go back to her maiden last name. Through the course of this turbulent ending of our marriage, she has stated several times that she hates my last name and that she has it. I was actually given my last name through adoption, so it holds quite a bit of weight to me. And I would ask that she go back to her maiden name, both, I guess, legally, but also on her various social accounts, being Facebook, Instagram, and Snapchat.
She always has the right to do that, Ms. Van Tattenhove. If you wish to take a former name, maiden name, etc., you can do so with an extra provision in the judgment. The court cannot require that she do so, so the court will not do so in this particular matter. Ma'am, just as assistance to you in getting this completed, you can go to various sites, but the one the court's familiar with is michiganlegalhelp.org. And they have in there, forms as to preparing a judgment of divorce, the uniform child support order, and the judgment information form. Sir, you're going to have to go to a site that would provide you with ability to provide or prepare a qualified domestic relations order so that you can, in fact, acquire the balance in those two retirement accounts. With that, the court will conclude this matter at 10:08. You're free to go. Have a good day, and I hope everything works out for both of you in this matter. So, you're gonna have to include all the provisions as it relates to the children in the judgment as well.
May I ask a question, please?
Sure.
I just want to make sure I pull the appropriate documents and get them filed as you're requesting. So I have the judgment of divorce and then Uniform Child Support Act. Is that
Order.
Thank you.
It's a form where fill in the blanks, et cetera. What you're gonna have to do is put the income that I've ruled on, your income of $2,800 per month, his of 74,000 per year. You'll have to divide that out. And then what happens, you'll have to put that into the calculation, and then you'll have to put in as well any overnights that he has the children based upon what you've agreed to. And then it'll kick out a number, and that's the number that goes in the uniform child support order.
Okay. And as
Then you
far,
have to do a record judgment information form. It's a form that simply has all of your contact information, identification number, and his as well.
okay. Got it. So those three items.
Documents, then you submit them to the front of the court for their approval. Once they have approved those, then you can submit those to the court at that time.
Okay, thank you for
And
reading.
sir, you're going to have to submit the qualified domestic relations order on your own after preparing that. Any of the orders that you submit, sir, you don't have to submit yours to the front of the court because they don't have anything to do with that. You can submit that directly to the court. If it's submitted within 7 days of today's date, you can submit it with a notice of entry. If it's beyond the 7 days, then you're going to have to notice it up for entry. Okay.
Was that just for Brian's due
No,
date?
that's for you as well.
Okay, so in 7 days.
And probably yours is going to be beyond the, because the front of the courts, especially with the holidays, it's taking about 2 to 3 weeks to get those approved. And then you just submit a notice of entry.
And when do these documents have to be submitted? You said 7 days from now?
So you need to submit those as soon as you can.
Okay,
I'm just saying, if you submit it within 7 days, then you wouldn't have to submit a notice of entry, but you're going to have to get front of the court approval. But you can still, if you have those, you can still submit those at that time. I will tell you, it's not unusual for people to get the front of the court to object to something, because being a lay individuals, you don't always include and check all the boxes that you need to check. But if you go through Michigan Legal Help, they do help you through the process as it relates to what you need to include.
okay.
Okay?
I do have one more question
Okay.
regarding the 401k disbursement.
Yes.
I have no problem in pulling and drawing that money. When does it need to be given to him?
Well, let me put it this way. Is it your intent to draw that out in the balance as of today's date and then provide that to him?
That would be taxes.
Sir, what was that?
That would incur a tax. I would just look
Correct.
for a trade. Can't you just transfer it into my name?
Well, that's what the qualified domestic relations order would do.
Okay,
So if you
I
do
just
that
wondered
order,
about the
then she
tax.
doesn't have to take it out. You don't have the tax obligation, et cetera.
Yeah.
Okay. Ma'am, then you can just leave that alone. Let him take care of that through the qualified domestic relations order.
okay, great. That's all I was curious about with
Okay.
that.
Thank you. The court will note that what you have submitted as proposed exhibit, the court will have those destroyed, and that will conclude this matter. We'll go off the record at 10:12 a.m. again. Good luck